All right. Okay, I'm going to go ahead and call this meeting to order. This is the properly noticed public meeting for the Child Support Guidelines Committee, October 15th, 2021 at 9 a.m. I would like to go ahead and do a roll call. Kathleen Baker.
Present.
Margaret Chappell.
Margot Chappell here.
Karen Cliff.
Here.
Assemblywoman Cohen.
Here.
Ellen Crecilius. Jack Fleeman.
Here.
Melissa Hardy. Senator Harris. Judge Hoskin.
I am here.
Senator Pickard.
I am here.
Judge Robb.
Here.
Joseph Sanford. Judge Shirley. Justice Stiglitz. And myself. 1, 2. We have 9 present. We have a quorum, so we can conduct business. Oh, and I just got a message from Justice Stiglitz that she is working on getting into the meeting. Let me see if we have her in attendees instead. Oh, she's coming up.
I'm in.
All right, perfect. I will mark Justice Stiglitz as present also. All right. Let's move on to the second item in our agenda, which is public comment. This is the time and place for those on the phone or in attendance on the link to give public testimony. Your testimony will be limited to 2 minutes per person. I apologize, but I will cut you off at any point that you give significant information that we perhaps would like to speak to you in further detail. I can always put you on a future agenda. Just reach out, please. No actions are taken during this part of the agenda. And at this time, do we have anybody for public comment?
If any of the attendees wish to provide public comment, please press *9 on your phone or raise hand button in Zoom to participate. Once again, if you wish to provide public comment, please press *9 on your phone to take your place in the queue or raise hand in the Zoom window, which is in the lower right corner. Chair, at this time, everything is working on our end. However, there is no one to provide public. We just had one caller raise their hand. One moment.
Okay.
Caller with
Hi,
the last
everybody.
3
This is Ryan
digits.
Songa from the Attorney General's office. I don't have a comment. I just wanted to tell everybody I was here. It keeps on muting me, so I wasn't able to tell you at the beginning.
Okay, thank you. For those of you that are part of the public, we have your phone numbers and see you as attendees, and you're noted as being present through either your phone number or your name if it is appearing as your name. And we thank you for your time. All right, any further?
Chair, at this time, there are no additional hands raised and there are no one wishing to provide public comment.
Okay, thank you. I appreciate it. All right, we're going to move on to the next agenda item, which is approval of the meeting minutes from September 17th, 2021. I believe there are a couple edits that need to take place. One being that Justice Stiglitz was present for the entire meeting, and 2, that she needs to be referenced as Justice Stiglitz. Are there any other additional edits that anybody notes for the meeting minutes?
Madam Chair, this is
Yes.
Bridget Robb for the record.
Just a note, there were some spelling and grammar issues. I didn't call them out individually, but one of the issues that does bother me is one either moves or makes a motion, one does not motion, and that is in the minutes several times that someone motioned. If we can have that corrected, I would appreciate it.
Absolutely, we can correct that. All right, that's noted. Any additional edits? All right, hearing none with the edits, do I have anybody willing to make a motion for the approval of those minutes?
Move to approve the minutes as Justice Stiglitz.
All right, thank you, Justice Stiglitz, for the motion. Is there a second?
I'll second.
All right, thank you,
Leslie Cohen.
Assemblywoman Cohen. Do we have any additional discussion? Hearing none, all in favor, state aye.
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 Anybody opposed? All right. Any nays? Hearing none, motion passes. All right, we'll move on to the next agenda item. Check a couple of things here. All right, the next item on our agenda now, just for cleanup purposes or just to note, we have, based on the last meeting, provided in the agenda under each agenda item, the ability to take public comment on specific items. So for those of you that are listening in attendance, when we take public comment on those individual items, it needs to stay relevant to the agenda item that we are on at that time. We cannot have you speaking generally about other agenda items, but that will be the proper time for us to get additional information from you on those specific items. Depending on how much public comment we have, I may provide more than 2 minutes per person, and because I want to actually solicit the information from the public on each of these items. I see that we have Senator Harris with us now too, so I will mark you as present on in our meeting minutes. So agenda item number 4 is discussion and recommendation on maintenance of the hearing videos and minutes from the commission in a public location for preserving the intent of the work of the commission. Do we have any committee members able to comment on this? I see Margot Chapel shaking her head yes, so you may go
Yes.
ahead and speak.
Thank you. Good morning, committee members and chair. We have an established website already on the dwss.nv.gov. It is in the process of being updated. Back to 2017, the minutes from the meetings have been remediated for compliance with the ADA, and so those should go up next week. And then within the next 3 weeks, we should have YouTube videos of each meeting also available. So that's all of that is in process, and this is our committee, so we own that, and we'll continue to support the committee's materials to be posted online. Thank you.
Thank you very much. Any additional committee comments or input on that? I will say from my comment, I believe that satisfies what the issue was and absolutely assists and aids in the future work of this committee too, because we won't be trying to restate what our intent is in each hearing. So thank you. We appreciate your efforts on that.
Absolutely. Thank you.
At this time, I will take public comment on agenda item number 4, if there is any to be had.
There are any participants wishing to offer public comment on the current agenda item, please press star 9 now or raise hand in the Zoom window. Once more, if you wish to offer public comment, please press star 9 now if you are on a phone, and if you are using the Zoom client, raise your hand. Thank you, Chair. It appears that there are no attendees wishing to give public comment at this time.
All right, thank you very much. We will move on to agenda item number 5, discussion and recommendations on cleaning up the language and the regulations on what is part of the formula versus what is an adjustment after the formula. Do believe that Judge Hoskin and Senator Pickard worked on some language for us. If you'd like to reference that work for us at this time.
Sure, I'll start and I'll let Senator Pickard clarify where we need some clarification. The intent was, at least as I understood the intent of what I was supposed to do, and Senator Pickard was supposed to help me with, was to incorporate 130 with regard to the childcare costs into 425, 140. I went back and reviewed it, and essentially what I did is I just moved 130 into 140 so that it was part of the calculation before the calculation ended. After some discussions with Senator Pickard, he suggested the very last portion of the language under F, at least proposed F, to add sort of a list, a non-exclusive list of things for the court to consider. My only concern with that was when we're adding lists, we remove some discretion. So from my standpoint, I had a little hesitation. The language does include, among other things, which makes me feel a little less anxious with regard to an additional list, but certainly Senator Pickard, if you want to address that.
Certainly. One of the comments we regularly get with any legislation that we provide to the courts is that we often lack the guidance necessary. And I hear that both from the appellate level as well as the district court level. So the idea was to offer a non-exhaustive list of things that we typically hear when arguing about this adjustment. And so that was the genesis of the desire to create the list. So we added both the language, among other things, and then the last of those factors is any other factor that the court deems relevant to the consideration. Because I agree with Judge Hoskin, we want to make sure that the district court has sufficient discretion to do what is fair under the circumstances, but we need to also provide some guidance. So the idea here is to cover the main issues that are addressed in the typical child care discussion, and then provide the court the ability to look at any other factor as that would weigh in. So that's how we came up with the list that we had. And by doing this, we can eliminate 425, 130 and simplify the understanding of the process of the calculation.
Okay, thank you. Do we have any additional committee comments on that?
Yes, this is Margot Chappell, wondering if that language could be shared, projected on the Zoom screen.
Oh, I could do that. Yes. They were provided with the agenda as materials, but I can get that on the screen for you. Hold on just a moment.
I know Senator Pickard mentioned it, but I just want to make sure the record is clear. The intent is to eliminate existing 425, 130 and incorporate it into 140.
Okay. Now I need input from the committee whether or not they're seeing the screen properly.
Yes, we can see it.
Okay. I can't tell from my end. So, okay. And I scrolled down. I believe F is visible on the screen.
Yes.
Okay. All right. And then I saw Judge Rob, you had your hand up for comment.
I did. I agree with Judge Hoskin. The way the language reads right now, this is yet another laundry list of findings that I believe are required pursuant to the language of the statute. If I'm reading this correctly, it says that the district court is to set forth specific findings concerning all of these issues, among others. So we can add to this list, but we are required to make these findings. My regular order with regard to child support is now running to 5 pages, and I've got to make additional findings pursuant to the statute here. I appreciate the guidance, but do we need to continue with these kind of laundry lists? Because many times these factors aren't applicable, yet I still need to make the finding. Can we tweak the language so that the court needs to consider these things and make specific findings?
If applicable, is that what you're suggesting, Judge?
I am suggesting, if applicable, so that we can get rid of some of this. Because, for example, child custody, findings 1 and 2 are almost never relevant to my findings, yet I must make a specific finding with regard to them. I'd prefer to cut out all of that excess verbiage.
So just so I'm understanding, you're suggesting that the cost of the childcare proposed and the cost of reasonable alternatives are things that would never be considered?
No,
No,
that wasn't
no,
what
no.
I said.
She's talking about 004, the first 2 factors in the custody of 004, 125C004. The wishes of the child and the nomination. That's what she was referring to.
Got it. Okay.
I was merely making an analogy, Senator.
Got it. Yeah, I missed that. I apologize. Because I was focusing on because I certainly agree, we don't want to create unnecessary effort. Often, particularly Judge Rob, you appear, although I've never practiced in front of you, you appear to be like Judge Hoskin, where if you are given a directive, you follow it. And so your orders can get fairly long. I, as a practitioner, don't mind that. I would rather have specificity, particularly where we're trying to make sure it's clear to the litigants. But there's no pride of authorship here to the extent that I'm not married to any particular list. I just was trying to cover the arguments that I typically make or hear when these become an issue. And so if we wanted to, but by the same token, we hear regularly that if we don't provide guidance, then we leave it up to the appellate courts to become the legislators. And so we take heat for that. So it's a balance, and I'm just making a suggestion to try to find where we can best strike that balance.
Understood, Senator. And yes, if you say shall, I do it.
Is it possible, looking at the language that's proposed, to perhaps put some language in there that findings are necessary on relevant pieces of those factors rather than completely?
If applicable.
And I'd like to do that across the board with every finding that I have to make, only if it's relevant. Do we have that power here?
Instead of listing the 100 things that don't apply in every single case. Yeah.
Thank you, Davis. Yes.
I like that tweak, Judge Hoskin. That would alleviate some of my concern.
Yeah, because I don't. While I'm on board with fewer lists are better, I do understand Senator Pickard's desire here, but I think there may be a middle ground here if we specify that only those relevant factors need to be in the findings of the court. I think that may solve the problem from my standpoint, and it sounds like from yours as well, Judge Rob.
It does. Thank you.
Yeah, and I have no problem with that. I think if we were to recraft this to suggest that the court shall make findings on all relevant factors, such as, something like that, we could accomplish it. I just want to make sure that, particularly with some of the judges, the new judges that are currently struggling with how to use this formula, which we are, and Judge Hoskin is fully aware of. I think that some guidance really will be helpful. So I appreciate that balancing, and we can certainly, Judge Hoskin and I can come up with language to better suit the desires of this committee.
Okay, so what I'm hearing is that with this input from the committee, on the next agenda, we'll have some modified language, perhaps to, okay. Are there additional comments? Senator Harris.
Thank you, Chair. I don't practice in this area, and so I wanted to make sure we didn't create a new problem by adding relevancy Is there room for, is there going to be some issue over which factors are relevant? Since we've added this, or is that something that we don't think would be, added ambiguity?
Well, the lovely
personally, I
part of,
don't-
oh, I was gonna say, the lovely
ahead,
part of
Chair.
practicing in family law is there is a lot of discretion. And what's relevant or isn't relevant is basically our entire, our entire practice, unfortunately, because it's best interest of a child. And it's, it's looking at kind of these gray areas like that. And so many families are so different that we've had to structure family law that way, to what's relevant, what's not relevant. We've got factors where we talk about special needs, and if you have a family without special needs, what they're talking about is the judge not having to say specifically, this child does not have special needs. I mean, is it helpful sometimes? But when a majority of your families don't have it, then you're just writing things to write things. But Judge Hoskin, you had an additional comment.
No, it was similar to what I was going to indicate. There's a lot that we do that we haven't considered whether it was relevant or not in creating the statute or the regulation, which results in, and I'm with Judge Rob, I don't know that I've issued a decree in the last 4 or 5 years that's less than 35 or 40 pages, just because I'm making findings on half of those pages are probably on findings that had nothing to do with the case that's in front of me, but the appellate courts have reviewed them in such a way that they need us to tell them that this doesn't apply in this case, simply so the factors are moved forward. So I think it's a good question, Senator, because we don't want unintended consequences with what we're doing here. And I haven't thought it through that way, but I don't anticipate, but certainly in the next few weeks between now and the time we come back, Senator Pickard and I will have that conversation and brainstorm with some of my colleagues and see if we can come up with something that may be an unintended consequence that we're not thinking of here today.
Yeah, and then Senator, I just want to tag onto that because I think that you raise a really good point. You're coming at this from a legal education, but not within the family law structure. And so you can offer insights to things that those of us that practice in this area just take for granted. But I think that Judge Hoskin just pointed to, something that feeds into Judge Rob's angst, which is the Supreme Court will tend to, and no offense, Justice Stiglitz, will tend to give direction in a specific case because they think they need specific findings, but then that, particularly if it's a reported case, becomes now directive for every case. And if we can act now to make it clear what we're trying to accomplish, give the courts enough guidance to exercise their discretion in a way that the appellate courts can appreciate, then I think we've addressed both of those issues in the balance. So I look forward to hearing from you when we come up with this next iteration.
All right, well, I'm happy to hear that you all love the ambiguity and live in it. I
didn't say we loved it.
Fair enough, fair enough. I hear relevancy and it automatically in my head, I'm screaming, no, Judge, that was a relevant factor. I can't believe you didn't even touch it, right? And so I want to make sure we're not getting to a point where now orders are saying, I find this isn't relevant, and so they just don't speak to it at all, and then that becomes an issue of litigation itself and in the appellate court. But I trust you all to handle that.
That's a very fair statement and very much the reason why we have such a diverse committee, and I love it. All right, Assemblywoman Cohen, I saw your hand for a second there.
Thank you. And I will admit, I am still absorbing as a practitioner 425. So maybe this really isn't an issue, but do we need to address change of circumstances with daycare costs? I mean, how are we, because daycare can, for some families, can change so frequently. I want to make sure that we're not going to set the court up for having some families that are constantly back in front of the court because of the change in daycare costs.
My comment, and then we'll take comments from everybody else. My comment would be twofold on that. One would be the issue of language regarding modification, which we went through on the committee that we decided we didn't have jurisdiction over or wasn't given, or we didn't have power over as a committee. And two, it reminds me of the emancipation discussion of, can you draft an order for a change in the future when you don't have the facts from the future? I think that same discussion applies to that, which I don't know how we can structure it and have it stay constitutionally sound based on the discussion we had in emancipation. I would still love for us to come up with a better solution on the emancipation part of it. We just aren't there. And I feel like that's the exact same conversation here, but further comments from others?
There is a workaround for that.
Judge
I
Rob,
believe.
so everybody say your name, please. I know we're on Zoom, so it's a little different because your name tag's there, but we still have to document this, right? So.
And thank you, Madam Chair. This is Bridget Robb for the record. There is a workaround that I believe judges in the North are using so that if there is a change, the order doesn't need to be modified. So rather than a straight dollar amount, you say that the parties are going to, for example, split the medical premiums 50-50 or 30-70, whatever is appropriate. And you can do the same thing with childcare costs. The parties are going to split those childcare costs using percentages rather than strict dollar amounts. That way the order floats and you don't need to go back and modify it every single time there's a change.
Additional comments from the committee?
Yes, Kathleen Baker for the record.
Yes, ma'am.
Just a comment with respect to the workaround that Judge Robb just pointed out. From an enforcement standpoint, unless the agency has specific dollar amounts, we would be unable to clearly enforce the child care or health insurance premium costs. That would be something the parties would need to be working on. So while I think that is a viable way to address it, it does cause some pretty significant problems if they bring it to child support enforcement program to enforce the order.
Okay, any additional comments from the committee?
Kathy
Chair.
Baker again. Oh,
Go ahead, Kathleen. Go ahead.
I just wanted to say, when we finished talking about the child care provision, I apologize. I was not able to attend the last meeting. I did notice that the notes talked about incorporating both the child care and the health insurance premium costs as part of the formula. And I don't know whether that's still to come or whether there's something that I'm missing and that was decided against.
And Judge Hoskin, I can probably address both of those. In my review, the health care is not a mandate to be included the way that it's currently written. We discussed it at the last meeting and determined that perhaps it wouldn't fit as part of the calculation since it wasn't mandated to be included in. And getting back to Assemblywoman Cohen's comment, the way that I would look at that, and maybe we need to look at it from a committee standpoint, is in the modification at 425-170. So I think at least the way that I see it currently, you have to show a change of circumstance with the child care costs in order to get that review as well. So that's at least how I would look at it from the standpoint now. If the committee thinks we need to take another look at that, then we probably need to make some adjustments to 170.
Additional comments from the committee?
I do have a question with respect to the healthcare versus the medical support. Are those two separate things, Judge Hoskin? Because I see medical support addressing with the requirement that parties have medical support for their children, and I thought that was part of the formula, versus the issue of whether unreimbursed medical costs must be shared. And so just some clarification, please.
Yeah, and in what's in 425-135 is essentially a mandate to include those issues in the order, but not necessarily to include it as part of the calculation of the child support. So the hope was in incorporating 130 into 140 that we would clarify for the judicial officer what was expected with regard to the formula. And at least my understanding, and certainly I can be corrected on that, 425-135 isn't essentially something that we're dealing with as far as calculating child support. And maybe I'm wrong on that, but that's how I understood it.
Additional comments from the committee?
Kathleen Baker, for the record. My recollections of the previous committee meetings is we were trying to get rid of deviations. We now have adjustments. And one of the deviations was for the cost of the child's health care insurance. That is no longer an adjustment. So are we just, so does it, I'm just sort of seeing, where does this fit in? Does it fit in as part of the formula? Is it just something sort of new and different that we add in that isn't an adjustment? So in terms of where it fits in, I know that the court that I'm in front of right now really tends to look at the health insurance sort of as an adjustment because it's not set out as part of the formula, and I don't know where else we put it.
Additional comments from the committee? I'll comment. Ms. Baker, I believe I'm of the same mindset that medical insurance was supposed to be a mandated part of it. How we ended up with the exact language we ended up with, I thought was partly in part because of the needs and requirements of DWSS. We learned during our committee meetings that the issue of the medical insurance and or medical support, however you term that, was a critical issue for them and a critical issue in terms of compliance with the federal government. So I tend to agree with you. I also tend to worry that we're going to get 140 too detailed to be so expansive and so long that it's unwieldy. And part of it was how it was drafted into LCB at the end. Any additional thoughts or comments on that?
This is Keith Pickard for the record. You know, I recall this back in the first iteration, and we were talking about whether or not the requirements of 125B020, where, and it's mirrored in 125C001, where the parents have an obligation, an outstanding obligation to provide the medical support or support for their children. And 125B020 specifically talks about to provide health care. And so I had, my recollection is that because this is a pre-existing duty, it doesn't have to be part of the child support calculation. It's a duty that the court may order based on the equities of the case. Both parties have an equivalent duty to cover that, and then the court can do what the court thinks is fair in terms of assessing or allocating those costs. My recollection, though, is that we decided not to include that in the calculation, particularly given the case law that said that you know, that deviation is the exception, not the rule. And so if one party is ordered to provide the insurance, then that party provides the insurance, so long as it isn't greater than that 5% of their GMI or whatever. I forget how that's calculated off the top of my head, but that was addressed in the statute and not within the purview of this committee. So we left it alone.
I agree.
I agree. This is Karen Cliff on behalf of the Clark County DA's office, and I want to second everything Senator Pickard just said. So.
Okay, thank you, Ms. Cliff. Any additional comments from the committee? Okay, before we go into public comment, then I believe I want to just summarize that Senator Pickard and Judge Hoskin are going to rewrite the language based on input and comments during this meeting and come back, and we will keep this on the agenda for the next meeting.
Chair Surratt,
Yes.
can I entertain having comments from our staff, please?
I think that's a great idea.
Thank you.
Because what we do here will affect them on a more regular basis than the typical practitioner, since that's only a subset of what we do. So absolutely, if you guys want to weigh in, just send the comments to Judge Hoskin and I, or just Judge Hoskin, that's okay. I'm kidding. But yes, absolutely, we would love to hear from you.
Thank you.
All right, thank you. At any time your staff want to comment, there's multiple routes. There is getting on the agenda. There is appearing here as an attendee and participating in public comment, or there is providing direct input to any of the members of this committee. Not all of us all at one time. We cannot communicate with the public that way without being in violation of the public meeting laws. But individually, you can reach out to a committee member. They'll take your input and they'll make sure it's conveyed to me or to co-chair Senator Pickard in order to get it on the agenda.
Thank
we
you very
welcome-
much.
We welcome the comments at all times.
It's my understanding they're both on this meeting, so I will invite them then, based on your comments now, to make comments currently or to let us know that they will submit comments in writing to Judge Hoskin and Senator Pickard.
Perfect. And so I'm about to open up public comment.
Thank you.
Before I do that, one administrative item, which is to state that we have, I think is it Jeff Stroop? Is that how you say your name, Jeff?
It is Jeff Stroop.
And he is here on behalf of Ellen Crasilius as a proxy. So we will mark her as present through a proxy. All right, thank you. All right, now for public comment on agenda item number 5, which was the discussion and recommendations on cleaning up the language and the regulations on what is part of the formula versus what is an adjustment after the formula. Do we have any public comment on this item?
To speak on the matter at hand, please press raise hand in your Zoom window or press *9 on your phone to take your place in the queue. If you have your hand raised, you are unmuted and may begin.
Good morning, Madam Chair, members of the committee. My name is Marshall Willick. I'm the observer from the Academy chapter. Pursuant to the requests that were made at the last meeting, we did an analysis of the announced complaints and problems that have been showing up in a couple of both ongoing appeals and a couple of recent decisions. And we came up with 6 subject areas that we think would be helpful. It might be useful if I could have somebody to submit some of this to in writing, although I'll be happy to mention some of it verbally as well. We took a slightly different.
Mr. Willick, I'm going to stop you for just a second. I'm going to let you do your summary of information from AAML, but on this one, unfortunately, because we have to stay specific to the agenda item, are any of the AAML comments specific to the agenda item number 5 so that I don't get in trouble for not staying on the agenda? Okay, thank you.
Yes, that was our item number 2. We took a slightly different approach to the 130, 140 medical support and cost of childcare problem by altering the order of, or proposing a change in the order of the regulations and calculations, which we think would eliminate some of the confusion among courts and lawyers as to what is to be calculated in what order, which has led to inconsistent interpretations and results. We think it can be most easily rectified by reorganization of the order of steps, which we think will lead to more consistent interpretation of how to perform calculations across a range of fact patterns. For example, a phrase could be added to 425-100 or maybe 140, specifying that child support should be calculated after all other transfers of funds, such as alimony, between the same parties. We have more to say about the order of calculations, but basically we would leave medical support and cost of childcare as separate items to be done after the formula, which might eliminate Judge Rob's too many factors consideration as well, because it would simply be an additional line in an order after the calculation is performed. There's more to say about all of that, but I don't want to exhaust my time. So if I could have some ability to provide detail in writing and somebody to direct it to, I'd be happy to do that.
Yes, sir. Thank you, Marshall Willick, for the input from the AAML. And I would suggest that you submit that suggestion to Senator Pickard, and he and Judge Hoskin will consider it for their next proposal on this item for the next agenda. And if you need to get it to me instead, I'll get it to them either way, but I know you can get a hold of either of them. So. All right, are there additional public comments on agenda item number 5?
If there are additional comments on agenda item 5, please press raise hand in your Zoom window in the lower right-hand side, or press star 9 on your phone to take your place in the queue. Chair, at this time, everything is working, but there seems to be no additional comments.
Okay, thank you very much. We will move on to agenda item number 6. Now I will comment just for the sake of how this meeting is going with the additional public comment. Of course, it is taking us longer to get through items, but we also have more substantive conversations. So if we don't get to everything, we will just keep rolling it over. And for additional comment based on Ms. Baker, you weren't here last time. So we have several of your agenda items that you requested that we basically skipped last time for the sake of waiting to hear your input on them when we get to those items. And same thing with you, Senator Pickard, on joint physical custody calculation. So the next agenda item number is 6. It is discussion and recommendations on adding language to NAC 425.0251 on gross income to clarify self-employed income is after deduction of all legitimate business expenses, but without deduction for personal income taxes, contributions for retirement benefits, contributions to a pension, or for any other personal expenses. This item was on the last agenda. The discussion was not to make that clarification, but out of respect, Ms. Baker, we wanted to make sure you had some input in the meeting before a final decision was made on that.
Thank you, Kathleen Baker, for the record. This came up because it has become an issue in a number of our hearings. It may just be our hearings where we're coming up, but we've had a number of discussions from mostly custodial parents who do not, they're pro per, they do not understand the concept of business expenses. The court is still using that when they are adjusting it, but I thought it would be helpful to clarify for lay people. And if this committee has determined not to add it, I would submit to that decision.
Any further discussion from the committee? Senator Pickard, you have your hand raised?
Yes.
Which, thank you, by the way, everybody. We are on Zoom, but we do need that decorum a little bit. It helps me a lot. So thank you for raising your hand.
Thank you, Chair Keith Pickard, for the record. I was actually somewhat hesitant when I saw this on the last agenda, and then I just lived through a real world experience where the judge that I was before, who is not present today, was completely trying to find a non-pejorative term here. It was not understood how the tax code works in terms of business expenses. And there were things such as coffee machines and vehicle costs and various items that are depreciated from taxes that are allowed under the IRS rules. And then there was an explanation, well, these are office expenses, but the admission was that it was a one-person office in the home. So, you know, we can be really creative as business owners in how we work with the IRS code to include personal expenses. And this member of the bench had no real understanding of how that worked. And so I have become a sudden proponent of this kind of clarification. I think it will be very helpful to explain that, and this goes probably more to the pro pers, as Ms. Baker suggests, but to explain that legitimate business expenses are expenses that go to the operations of the business. So costs of goods sold, you know, the costs that are actually unavoidable as an operational expense, but don't meet a personal need only. So the things like the coffee machine and the carpet cleaner and the things that went into the home expense that can be written off, those are not legitimate business expenses when we're talking about an individual who works from home. Those are the kinds of discussions I think we really could use in the discussion about gross income. And so as I say, I've become a proponent of this idea.
Thank you. Ms. Chappell, you are next.
Margot Chappell, for the record, thank you. Wanted to go on the record as saying the program is very supportive of this language change to clarify that. Thank you.
Thank you, Ms. Chappell. Any other comments from the committee? Keep having my voice cut out. I'm sorry. Ms. Cliff.
Hi, this is Karen Cliff on behalf of the DA's office. I agree with Senator Pickard as well as Kathleen. The clarification would be beneficial. I am concerned that it might still create quite a bit of ambiguity and questions in terms of what is considered a legitimate business expense. I think we've all discussed it and we know what would be considered a legitimate business expense. I'm just wondering if by adding the verbiage, we're adding sort of more litigation. You know, I support what the committee wants to do in either direction. I'm just not sure if this clarification will just add more litigation, really.
All right, thank you, Ms. Cliff. Mr. Fleeman.
Thank you, Madam Chair. Jack Fleeman for the record. I think Ms. Cliff might have just answered my question, but I wasn't here at the last meeting, so I was curious as to what the opposition was. It sounded like it was opposed by most of the committee members last time.
I'll do my best to summarize it. I don't know that it was a strong oppose as much as it was just, are we making changes for the sake of making changes when we have some case law and we have other places to go to for it. But in terms of litigation around it, my response too would be that was the exact language from the old statute, which we operated under for many, many, many years. Without extreme litigation over it. Yes, you had cases where they fought about it because somebody was always trying to push something as legitimate that wasn't. But I wouldn't say it's going to be an increased amount of litigation over what we had before on the issue, at least not in my foresight, not what I think it would be. But additional comments from the committee. Ms. Cliff, are you commenting again, or is your hand just still up? Now it's down. All right. Any additional comments from the committee? Do we have a proposal from the committee for a motion?
This is Senator Pickard. I will move to adopt this language as written. I think that it's broad enough, but clear enough to get to the point.
Okay, for clarification of the motion you just made, I want to read it because there is a missing quotation mark in the agenda. So I just want to make sure we are stating that under 425.025 subsection 1 for gross income, to clarify that self-employed income is, quote, after deduction of all legitimate business expenses, but without deduction for personal income taxes, contributions for retirement benefits, contributions to a pension, or for any other personal expenses, end quote.
That's correct.
Okay. Do I have a second on Senator Pickard's motion?
Jack Fleeman, I'll second.
All right, thank you, Jack Fleeman. Do we have any further discussion? All right, all in favor, state aye.
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 Anybody opposed? Are there any nays or nays, absentees? All right, thank you. Motion passes. All right, so for purposes of ongoing accumulation of these changes, for the next meeting, I will keep it on the agenda just for the purposes of demonstrating the exact language we are proposing so we can approve it and it's in writing. Do we have any public comment on agenda item number 6 at this time?
If you would like to offer public comment on agenda item 6 of today's meeting, please press *9 now on your phone or raise your hand in the Zoom window. Once more, to take your place in the queue to offer public comment, please press star 9 now if you are connected by phone, or raise hand in the lower right-hand menu of the Zoom window. Thank you, Chair. It appears there are no callers wishing to offer public comment at this time.
All right, thank you. We will move on to agenda item number 7, which is discussion and recommendations, clarification of NAC 425.025, subsection 1M, the inclusion of alimony and gross income in the regulations versus NAC 425.025, subsection 2, that does not exclude or deduct alimony paid from the obligor's income. Don't remember which committee member was assigned to work on this, but do we have any comments from the committee at this time on that issue? All right, I think what is best on this item is that we move into public comment, because I think that's what we are actually seeking at this time on ways to deal with this issue, if I don't have any objection from the committee at this time. All right, we'll take public comment on agenda item number 7.
If you wish to make public comment on agenda item 7, please press raise hand in your Zoom window or press star 9 on your phone. If you have your hand raised, you are unmuted and may go ahead.
All right, Mr. Willick, I'm going to allow you 5 minutes on this if you need it.
Thank you, although I think I can be briefer, especially if I have the ability to supply something in writing. The
Okay.
alimony problem is a bit more nuanced than most litigators and even some judges have seen, because alimony and child support could be paid by the same obligor to the same obligee, or could be in opposite directions, and could even include payments from third parties for either child support or alimony flowing either in or out to or from either an obligee or an obligor. When we tried to put this by diagram, we came up with at least 8 different scenarios, which would lead to, again, unintended consequences if they weren't fully thought out in advance, depending on trying to define your way into solution to the alimony problem. This is the second area where we believe that the best approach would be to specify the order of calculation, which should regularize and take care of the nuances of the variations in the fact patterns. The various alimony possibilities are related to the multifamily problem, which this committee briefly addressed, but elected in its last go around some years ago not to address at that time. In practice, the first mortgage approach, in other words, income not including funds already directed elsewhere by pre-existing court order, appears to be used in most courts and is probably the fairest approach. The question really, and this comes back to Judge Hoskin's question, is whether to provide for it explicitly in the regulations in place of or in addition to the more general support of others adjustment factor, which essentially boils down to a question of whether greater uniformity or greater discretion is intended by this committee. We have created a suggested phrasing, and I can supply it as you've directed to committee members Pickard and Hoskin with a copy to you if you wish, which might make it a little clearer than can be done in a verbal presentation. This is, again, related to the order of calculations and somewhat to the terminology, which we haven't discussed in great detail.
Okay, thank you. Yes, if you could provide it to Senator Pickard and myself, they'll take it into consideration for the purposes of the order of the calculation, and I will take a look at it in terms of applicability to the rest of the agenda and other items where it may fall. That way I can get us lined up with each of the items. I appreciate your time, Mr. Willick. All right. With that, is there any additional public comment on agenda item number 7?
To provide public comment, please press raise hand in your Zoom window or star 9 on your phone to take your place in the queue. Once again, that's press raise hand in your Zoom window or star 9 on your phone. Chair, at this time, it seems there's no additional public comment.
Okay, thank you. We will move on to agenda item number 8, discussion and recommendations on NAC 425.125 subsection 1 to determine if the without good cause language needs to be modified to include individuals who are unemployed or underemployed because of their household members make sufficient money for the person to not work. We did have discussion during the last meeting regarding this issue, and Ms. Baker, we left it on the agenda to get any further input and comments from you on this topic.
Good morning again, Kathleen Baker. One of the issues that has come up, at least in enforcement cases, is where we do not have the non-custodial parent obligor present, and we have no information verifying whether they are working or not, and whether they have any work history. So in those cases, we usually like to try and set some kind of an obligation, which would mean some kind of imputation of income. So that's a gap in here that I think that we're struggling to fill, because we have literally, we don't know whether they're underemployed or unemployed because they aren't present at all. And if anybody has any suggestions on how to possibly address that, maybe it's not in the NAC, but it certainly is a struggle, because the court doesn't have the authority in those cases under the NAC to say, I'm going to find that they're capable of making this amount of money, because they can't make this first finding.
Okay, thank you. Senator Pickard, I see your hand is raised.
Yes, thank you. I'm curious. I need some understanding because what you just described, Ms. Baker, seems to be different from what's written in the agenda item. When I read this, I'm thinking in terms of, a parent whose spouse makes enough money that parent decides they're going to be staying home with the children. They don't need to work. And so now their income is technically zero. And it may very well be good cause for them to stay home. Imputation may or may not be important in that situation. But that seems to be different from what you just described in terms of a non-present litigant, an obligor who isn't there. You haven't apparently obtained the financial information from that individual. So you have no basis to know what the actual income is, if they actually make any income, or we just need to impute income in order to move forward. And I don't know that those are the same thing. So can you explain, can you help me in understanding the difference between those two scenarios?
Kathleen Baker, for the record. When I was looking at this, I actually was not thinking about the issue of a spouse who is staying home because their husband or wife can support them. I think that is also a situation that falls into this category, but I think that they are two separate scenarios. It's not on the agenda here, but when I had brought it up, I was thinking about the other one. So I went ahead and put that in there. I agree that I think that if a stay-at-home parent is able to be supported by their spouse or person living with them and they don't have to work, there could be a good cause for that. They're taking care of the kids. But I think that what is happening, at least in my court, is that the judicial officer does not feel that there is enough direction here to be able to move forward with an imputation of income, given the necessity to make finding number one.
All right, this is Keith Pickard again. I personally believe that if a parent is staying home and they have a joint custodial award, actually, I guess the custodial award doesn't really matter, but as long as their income is being considered, if they are home because their spouse makes enough money, I think we should be imputing income. And so what I thought we were dealing with was we've got the language without good cause in there, which suggests that that's the condition in which imputation will occur. And good cause, could be, hey, I don't need this. I've got kids. Why go spend money on childcare because I'm working when I could just be home? We don't need the money. Those situations, I think, warrant imputation of income because it's unfair to the other parent to be essentially shouldering all of the expense. Now, I understand too, we have the adjustment factor for household income, which is usually where this is resolved. But that's what I thought we were going at with the without good cause language. So, but I think you have an evidentiary problem, Ms. Baker, with what you're describing. So I understand your judicial officer's hesitance to impute income when we don't have enough facts about that obligor anyway.
Of the cause itself. What is it?
Yeah. Yeah. And so I would think from an evidentiary standpoint, if you don't have the input required from that individual, you don't know if they fall, for example, within the low income table. You don't know if they maybe have a real reason. Maybe they're disabled, though not on the public rolls. There may be a host of reasons why imputation would be inappropriate. So I would think that that would be more of a question of an evidentiary standard that's required. You need to make specific findings about that individual. And if that requires maybe empowering the court to take the individual into custody for purposes of, and I'm not recommending this, but if there's some way of compelling that information to be disgorged, then that would be more appropriate than simply saying, well, he's not here, let's impute income, because I think that opens up a Pandora's box moving forward. But that, again, I misunderstood what item number 8 was about. So that's why I'm trying to wrap my arms around your fact pattern.
Ms. Cliff, do you have any insight from the South? I always put you on the hook on some of this stuff. Sorry,
Yeah.
but it helps to hear what's happening statewide to pull it together.
In Clark, we very rarely impute income, and especially with the new NAC, I mean, the findings that would need to be made. In Clark, we review the totality of the non-custodial parent situation. So fortunately, we do have access to Social Security benefits, unemployment, public assistance, being able to view whether they're receiving state medical, food stamps. So we look at their education, we look at all of those things. There's not necessarily a finding, but if we're unable to find historically any income, we're unable to find any present income, at that point, we're not really imputing income. It's just we don't have evidence of income. So at that point, we do use the low income table. And that support amount is generally set at, $84.85, just depending on, of course, what chart we're looking at. But income is zero. We will not impute income after reviewing all of those various databases. If income is discovered later, then that would be a modification because obviously that is a change of circumstance. So that's how we satisfy all of those sorts of cases.
Okay, any further discussion from the committee or comments?
Kathleen Baker for the record.
Yes.
I would just say that our court also tends to look at the low income schedule, but in essence, that's imputing some income to be able to qualify for the low income schedule or using it as a minimum, which we as a committee eliminated. So I think it's problematic. It may be more endemic to the enforcement programs, certainly than it is to private practice, but it is problematic figuring out what to do when you don't have any income and you don't have any parties in front of you and no information.
Right. So this is Karen Cliff from Clark again. Just to clarify, we don't necessarily use it as a minimum. We understand there's not a statutory minimum, but in Clark, let's say we're at $84, there's one child on the case. We review whether the respondent has a history of incarceration. We review the petitioner's application for, was he working at the time they met? What's that education background? Historically, has he or she ever had a work history? We look at whether the respondent has other cases. Are they making payments on those cases? What are those orders set at? Kind of going back to that serial parenting situation. How many other cases or children does the respondent have? At that point, it's not necessarily $84. The appropriate amount may be $40 or $50 for that case. So I just want to emphasize we do not have a statutory minimum here in Clark.
Any additional comments or questions from the committee? Okay, then at this time, what I believe I am hearing is that we won't keep this item on the agenda unless future proposed language arises that somebody has a brilliant idea to help cure this problem of non-participatory individuals within the court system, which we would love to cure across the board, of course, but it may be worth asking our auditor at the point where we do another audit if any other states have ways of dealing with those cases or assisting with those cases. Not sure what the federal commentary is on that, but I'm sure it plays into the ability to pay language, because if you make an order that is an inappropriate amount that they are unable to pay, then we're backpedaling right back into the same problems again. At this time, I will take public comment on agenda item number 8, if there is any.
To offer public comment on agenda item 8 for today's meeting, please press star 9 now to take your place in the queue over the phone, or press the raise hand button in the Zoom window. All right, participant with their hand raised, you are unmuted and you are free to begin.
Madam Chairman, Marshall Willick, we were not looking at this from the DA court point of view, so we didn't address that at all. But in the regular family courts, there is indeed confusion, despite the comments at the last meeting from a couple commission members that there shouldn't be, about income imputation and its relation to remarriage of an obligor with reliance on a new spouse's income. Some courts are imputing income to the unemployed spouse in accordance with the earning capacity of the parent. Others are treating some or all of the unemployed parent's new spouse's income as income for the guideline schedule computation, apparently based on their reading of 425-150 sub F. We believe this could be resolved by taking the first subsection of 425-125, adding it to the end of 425-120, with guidance that the imputing income refers to the obligor parent personally. The proposed alteration to 425-150 sub F we've addressed separately. The without good cause limiter for underemployment we believe should be eliminated entirely, because an obligor may have a very good and good faith reason, such as irrelevance of personal earnings based on remarriage, but still have income imputed appropriately under the regulations. We have a suggested rephrasing of the provision, which we believe will accomplish both of those ends. And we believe that restructure would self-solve the retirement aspect as well, since earning capacity is necessarily reduced when someone reaches normal retirement age. The remaining sections of 425-125, which are the factors for calculating underemployment, could be dropped much lower in order in the regulations as simply detail for how to do such a calculation if imputation is determined to be necessary. And again, we can supply that in writing, which I think will be clearer than a verbal presentation.
Okay, thank you, sir. If you could provide that to me, I will make sure the exact language ends up attached to the next agenda, which will allow this committee to consider it at that point. All right, do we have additional public comment on agenda item number 8?
If there are any other callers wishing to offer public comment on agenda item 8, please press star 9 now or raise your hand to take your place in the queue. Thank you, Chair. It appears there are no other callers wishing to offer public comment at this time.
All right, thank you very much. We will move on to agenda item number 9, discussion and recommendations on NAC 425.100 subsection 2, and if, quote, basic needs of a child, end quote, should be defined. We did discuss this at the last agenda or last committee meeting. And we had several members not present. If anybody has any additional comments to give on that agenda item. Ms. Baker?
Thank you. And again, I apologize for not making the last meeting. I did want to clarify, I was not concerned with basic needs of the child in terms of a definition. I was actually looking at what is now item 16 on our agenda. So
Okay.
I do not think it's necessary to have a definition for basic needs of a child.
Okay, thank you. Well, that's the reason we kept it on here, to make sure we got that input from you, because we weren't real sure ourselves. So we appreciate it.
Thank you.
All right, if there is any further committee comment. Seeing none, then we will go to public comment on agenda item number 9.
If you wish to make public comment on agenda item 9, please press star 9 on your phone or press your raise hand button in Zoom to join the queue. You are unmuted and may begin.
This is Marshall Willick again. We did an analysis of all of the language actually used, and we realized that there was some difficulty because it went from the commission to either the LCB or a subset and then came back in a slightly different order. We believe there's a problem, an ongoing problem with inconsistent terminology, leading to some uncertainty as to what is and is not being assumed or referenced in various subsections, including the words base, basic needs, schedule, and guidelines. We suggest uniform references and cross-references. For example, 425.100 speaks of guidelines, but 425.140 speaks of a schedule, leading some judges to believe that there are multiple steps for adjustments at more than one step, more than one place in a court hearing, which some of the members of the commission at the last meeting didn't believe should happen. For example, as to income differences between the parties, which was the example that was being used during the last meeting. We believe this is easily resolved by specifying that adjustments are to the guideline schedule and using the reference guideline schedule in all places where the schedule, as opposed to the entire regulatory scheme, is the intended reference. Once again, this is probably clearer by red line, but we believe that the elimination of words that are not properly cross-referenced in other subsections will eliminate confusion that are leading to some of the decisions that we are looking at as problematic.
Okay, thank you, sir. Can you provide that red line to me?
Of course.
Okay, thank you. We will, for the next meeting, I'm going to start another master document. So those of you that were not with us when we first started the Child Support Commission, we kind of started working off of a master version of the NACs, well, at the time NRSs, with red lines so that we could start tracking what we were doing through the meetings. Because the end result of this will be that what we do then has to go to DWSS for them to do their public comment and public meetings before it can go to LCB. So I will start accumulating that for use in the next agenda. Do we have any additional public comment on agenda item number 9?
If you wish to make public comment on agenda item 9, please press star 9 on your phone or press raise hand in your Zoom window. Once again, that's press star 9 on your phone or press the raise hand button in the lower bar on your Zoom window. Chair, it seems at this time there is no additional public comment.
Okay, thank you very much. I appreciate that. We are going to move on to agenda item number 10, discussion and recommendations, clarification of NAC 425.100 subsection 3 and the language established pursuant to the guidelines. And if that language means with or without adjustments per the guidelines, Discuss edits to language to make this clear. Do we have any committee members willing to comment on this item? Okay, hearing none, I will move on to public comment next, but based on not hearing anything, we'll decide after public comment if we have enough comment for me to keep this on the agenda or not. Do we have any public comment on agenda item number 10?
Chair, Ms. Baker, I think.
Oh, Ms. Baker, sorry. Go ahead.
Okay, raise my hand. Kathleen.
You
Baker.
did, and I missed it. Sorry.
That's okay. Kathleen Baker for the record. This actually came up, I brought this up because we had a family bench bar meeting at which a number of the second judicial judges and a number of the members of the bar participated. And this was a question that was raised in that meeting as to what, and I was put on this hot seat from being on the guideline committee as to exactly what the intention was with respect to, meeting the basic needs of the child. Was it relying specifically on the percentage prior to making the adjustments? Or was it presumed that the basic needs of the child would be met when you took the percentages and then made the adjustments? So that came specifically out of that bench bar meeting. I said I would raise it at the next committee meeting that I was at to see if anybody has any input.
Okay, thank you. Any additional comments or questions from the committee?
Madam Chair, Keith Pickard, for the record, I think that this is something that Marshall was just speaking about. I think that we could wrap that in. I see Marshall has his hand up, so we'll obviously get to him. But I think this speaks very well to his point that being clear about the order and what is part of the calculation and then what is done subsequent to the calculation. I think that effort is probably timely and important. So I'm looking forward to seeing the AAML suggestions.
And I would probably say language choices too, as Mr. Willett pointed out about consistency in the language. And if we get some of those things fixed, perhaps we'll be on the right page. Before I move on to public comment, any other comments from the committee? I didn't miss anybody this time, right? Okay. We will move on to public comment on agenda item number 10 then.
You would like to offer public comment on agenda item 10 of today's meeting, please press *9 now to take your place in the queue or use the Zoom window to raise your hand. If your hand is raised, your mic is unmuted and you may begin.
Senator Pickard, and this is Marshall Willick again. Senator Pickard and Ms. Arad are exactly correct. That is exactly what we were hoping to address by the terminology changes and the order of calculation.
Okay, thank you, Mr. Willick. Any additional public comment on agenda item number 10?
Once more, if you would like to offer public comment on agenda item 10, please press *9 now or raise your hand via the Zoom window. Thank you, Chair. It appears there are no other attendees wishing to offer public comment at this time.
Okay, thank you very much. We will move on to agenda item number 11, discussion and recommendations on the language in NAC 425.115, subsection 3 for joint physical custody, and the recent legislative proposal to change the language to 1/2 of the difference versus the full difference in child support values. Senator Pickard.
Thank you, Madam Chair. This is something that harkens back to the original bill that I presented that created this committee. One of the things that has haunted us in this process is deciding what's fair. And when we're talking about dividing or adjusting, we've typically followed the Wright v. Osborne approach, which is we take, if somebody's making more than the other, we figure out what the difference is and we pay that to the other, to the person who makes less. Whereas that is arguably a disproportionate share of the difference. You know, and then we had the argument that, well, that person is less able, why should they meet in the middle? And so it was a policy decision, but I'm increasingly running across that in my practice where we have, particularly where you have a disparity that isn't, you know, huge, and yet we're asking one person to shoulder the majority. I just wanted to reopen the discussion because in my view, I think the dividing it in half is a fairer approach. But I just wanted to get the input from the committee to see if there's any appetite to address that.
Thank you, Senator Pickard. I will give my comment real quick. I believe it's much more fair to do the approach that is suggested in this agenda item. I would also state, though, that this is a very heated topic. Surprisingly, I'm surprised by how strong of opinions there are on both sides of it. And it may be that in part of it through the commission work was to just kind of default back to the old way of doing it because that's what felt comfortable to everybody. And that's really kind of where we went with joint physical because we didn't want to stray too far from it. But after talking to individuals we had in public comment in great detail, some of them minors out of Elko and Winnemucca, to actual public members, not professionals within our industry, I became far more convinced that it was much more fair to equalize them, like a balance sheet is the best way I can describe that, versus, you know, you owe the difference because you're the higher earner. We equalize everything else in family law on the balance sheet, but this doesn't seem to work in that same way. I've heard comments from individuals who stated, and they were professionals, not the public, that stated, well, it doesn't make any sense. If I owe you, and that's all there is to it. And I'm going to owe you that full difference. But that's not what you're trying to achieve, in my opinion, through this child support statutes. You're trying to achieve that each party has the equal amount of money. And in order to do that, you have to balance it. You can't just take the difference because now one has more than the other. It's been an ongoing problem, but I will take additional committee comments if anybody has any. Judge Robb.
Chair Surratt, I too have received quite a bit of comment with regard to this particular issue and have become convinced, as have you, that the balance sheet approach, to use that colloquialism, is the better way to go and the fair way to adjust between the two income levels.
Thank you, Judge Robb. Any additional comments? Okay. Does anybody want to make a motion?
I will make the motion. This is Keith Pickard for the record to alter the language of NEC 425-115 sub 3 for joint physical custody and adopt the recent legislative proposal that would modify the language so that the obligor pays 1/2 of the difference to the obligee.
Okay, for clarification of the record, there were other items in that legislation, I believe, or maybe other language, so it's just specific to this item.
Yes, that's correct.
Okay.
Yeah, I would
No
love to,
sneaking
but
something in there, Senator.
I suspect that since we don't have the jurisdiction to do the other things I proposed, that wouldn't work anyway. So, but yes, that's a good
Bingo.
clarification to make.
Okay, do I have a second? Oh, Judge Hoskin, are you a second? Let's get a second and then we can do discussion before we move on. Do I have a second?
I'll second.
Judge Rob seconds. Any discussion? Judge Hoskin?
Yeah, my only concern, certainly, if I don't understand the math, and I've done it this way for 30 years, so it's going to be hard for me to make that adjustments. But I certainly trust the people that have done the math on this. My concern is, are we opening the door on the modification side that everybody that has a joint physical custody child support obligation, once this legislation kicks in, now we're modifying all of them at one time? And is that something that we're contemplating as part of this change?
That's a great point. One that I hadn't obviously considered in this context. We probably should add language to suggest that this on its own does not constitute a significant change for purposes of modification.
We, of course, put that into the last changes we made. I understand there was at least one appeal done on it. I don't know the resolution of that. I don't know if it succeeded or not. I was one of the only committee members, other than the other private attorney, who voted against that provision. So, because as I stated, I feel like my position on this committee as is a representative of the private bar and the private public, and not to sound harsh, but my concern as to whether or not the court's gonna be overloaded with something is not something for me to consider, and whether or not it's fair or just for the public. But additional discussion on that item. Ms. Cliff.
I'm sorry, Ms. Cliff, let me just throw in, we may not need it. I went back and looked at 425, 170 sub 3, and we've already dealt with that potential. So I don't know that we need to, I withdraw my comment. How's that?
Okay.
Right.
Ms. Cliff.
This is Karen Cliff on behalf of the Clark County DAs. Before we vote on this today, is there any appetite to maybe run the math with individuals in various income levels to see what this new calculation would look like, both with a high and low income earner, both ways? You know, maybe just present the math so people really understand what this change and how it will impact them as a family.
I believe I think that is fair. In order to accomplish that through proper procedures. Yes, Senator Pickard.
I'll be happy to withdraw the motion for that purpose. I think that's probably a good idea.
And Judge Rob, do you withdraw your second?
I do.
Okay, thank you. Then we're back where we can do that. I also think it might not be harmful for us to hear a little bit of public comment on it too before we have a final vote on it. Because this makes it a little bit hard where how the order is with public comment versus our committee discussion. But
I'm sorry, this is Senator Pickard for the record. Something that Ms. Cliff's comment raised in my own mind was it will also require a change to the calculators that are available online. And that's going to be something that we'll want to make sure that they're looking at. Obviously, these wouldn't be adopted and promulgated until we get through the DWSS process in the Legislative Commission. But that's something that's going to take several people, particularly those in the private sector that have calculators on their websites. We're all going to have to adjust. So getting public comment might be helpful, although I don't want to raise that as a potential reason for not doing this, because I do think that this is the fairer approach. I think the math is really straightforward. It's just we go through the same steps as we go now. So we look at the calculation under obligor A, we look at the calculation under obligor B, we determine what the difference is. Now we just divide it by 2. And the obligor who earns more or has the larger obligation pays that half of the difference to the other. So the math is actually quite simple in concept, but in operation in the websites, it might take some time to get that done. Although we did it successfully for this last or for the first iteration of the NAC. So I do think that that's doable. I don't want that to become an obstacle to accomplishing this, but I think it's a point well taken.
Ms. Chappell.
Margot Chappell for the record, just for note for the committee, the new NV Kids data system we'll do the calculations and the math. So just so you all know that, thank you.
Oh, that's a relief. Thank you. Without a big fiscal note is what I'm hearing. Okay. That makes things much better. Ms. Cliff, was your hand still up or do you have an additional comment? I love how she just takes it down. Okay, perfect. And do I have a volunteer to run some scenarios to have them prepared for the next meeting? We don't have our lovely Mr. Sanford who did all of our algorithms and charts for us last time because he's brilliant at it, but.
I am happy to run the samples, both with the guidelines as they stand, the formula as it stands, and then what this change would do. And I'll pick them at various income levels, both from the low income chart percentages, as well as what it would look like on the high income side.
Okay, thank you. I appreciate that, Ms. Cliff.
And I'm happy to volunteer support in that effort, Ms. Cliff, if you'd like it.
All right, I think that was a thank you. I saw her lips. Okay, do we have additional committee comments before I move on to public comment? Okay, hearing none. Can we please now take public comment on agenda item number 11?
If you wish to make a public comment on agenda item 11, please press star 9 on your phone or press raise hand in the lower right Zoom window. Once again, that is press star 9 on your phone or press the raise hand button in the lower right Zoom window. Chair, it seems there is no one wishing to make public comment at this time.
Okay, thank you very much. We will move on to agenda item number 12. Discussion and recommendations, clarification on the low income schedule provided in NAC 425.145, and discussion of use of the table as a minimum child support obligation. We had discussion last time regarding this issue and quite a bit of committee comment, but with missing members of the committee, we kept this on the agenda to keep discussing it. Do we have further comments from anybody on the committee? Ms. Baker?
I just wanted to say I did read the minutes, and again, Kathleen Baker for the record. It sounds, I would agree that this probably is a training issue. There have been issues about how to use the low income schedule, whether or not that you just use the amounts that are there and apply it to everything between, 816 and 805 or whatever it happens to be. So I think it's a training issue that can be easily addressed that way.
Okay, thank you. Additional committee comments? All right, we will move on to public comment, and unless I hear additional reasons within public comment, I will be removing it from the agenda with the hope that the clarification is out there with our meeting minutes and the YouTube videos being placed on the DWSS website. My hope is that it will clarify things for individuals. Do we have any public comment on agenda item number 12?
Offer public comment on agenda item 12, please press star 9 now to take your place in the queue, or use the Zoom window to raise your hand. If your hand is raised, you are unmuted and you may begin.
Marshall Willick again, very briefly. Whether or not the commission chooses to change the phrasing to specifically allow a zero amount, we believe this is one of the places that the reordering will be useful. Essentially, we're suggesting, as was done in the 16.2 drafting, it may be fruitful to open the regulations with escape clauses for non-application of the guideline schedule. There are two in the current regulations, one relating to stipulations, the other relating to low-income obligors, and then move on to the guideline schedule, then adjustments to that schedule, and then to sums calculated outside or in addition to the guideline schedule sums.
Okay, thank you, Mr. Willick. Based on those comments, I'm going to still remove it from the agenda as a specific item, and it's going to stay within an agenda item for the next meeting that is regarding the order and language of the NAC specifically to address that issue. Do we have additional public comment on agenda item number 12?
If there are any other participants wishing to offer public comment on agenda item 12, please press star 9 now, or use the Zoom window to raise your hand to take your place in the queue. Thank you, Chair. It looks like there are no other callers wishing to offer public comment at this time.
All right, thank you. I know this is a long meeting. We're still going at it. Hopefully we're okay without breaks right now because I'd love to knock it out. Agenda item number 13, discussion and recommendations on NAC 425.150 subsection 1 to determine if the old deviation factor of amount of time the child spends with each parent should be reinstated. Again, this was out of courtesy of the fact that we did not have all of our committee members last meeting, that we kept this on the agenda for right now. Do we have any further comment from the committee on this agenda item? Ms. Baker.
Kathleen Baker for the record. This was an issue that I brought forward. I find that at least in our court that one of the adjustment factors that the court wants to use is a time spent. Not everybody goes into court to do a joint physical custody arrangement. And if you're not doing joint physical custody, there's a very difficult time to acknowledge that the other parent has responsibility for caring for the child. So I think it's something that would be helpful to consider if the parent is spending a significant amount of time with the child, but not enough to make it joint physical custody, that should be something considered as an adjustment factor with discretion to the court.
Okay, additional comments from the committee? Mr. Fleeman?
I wasn't present last time I read the minutes, but it seems like it would kind of muddy the waters. The joint physical custody child support explicitly takes into account that there's a parent who has more time, potentially primary custody, I should say, takes that into account. In terms of joint physical custody, though, like under Bluestein and some of the other cases, I mean, if it's very close to 40%, the court can still make a determination. My understanding is that it can still make a determination of joint physical custody. So I think this is kind of just adding a layer of ambiguity as to what the court should do. It says, okay, if it's joint, this is what you do. But then at the same time, the court is going to be expected to say, well, it's 38% of the time, that's close to 40. So I would be opposed to this type of language. I think it's just very confusing.
Okay, thank you, Mr. Fleeman. Senator Pickard.
Thank you, Madam Chair. Keith Pickard for the record. I am going to weigh in on the same side as Mr. Fleeman on this, because when we were dealing with 125C 0025, or no, it's 003, 1A, where we kind of reinstated the 40% position but we converted it to a forward-looking instead of a backward-looking analysis. We made the statutory decision, ultimately the policy decision that 40% is a sufficient demarcation for that consideration. So we're talking about if you have less than 40% of the time, it's not going to be sufficient to call it joint physical custody. Now, Bluestein obviously has allowed the courts to apply the label wherever the court deems it necessary, and I don't disagree with that. But when we're discussing joint versus primary, we've already made that time calculation or that policy decision in 003. So I don't know that putting the adjustment factor in would do anything other than, as Mr. Fleeman suggested, muddy the water. because we've already made that policy decision in the statute, and we don't have the ability in this in our purview to play with that. Ultimately, we would be creating a discord with the statute, and I think that would be a mistake.
I will comment, Ms. Baker and Ms. Cliff can correct me if I'm wrong, but I think they're also dealing, this is that difference between the private versus the DA's world of dealing with clients or individuals who do not have a custody decision like we do. Ours will always have it. We will always have taken that step in the private world. But they're dealing with people showing up with no custody orders, yet still child support obligations. I don't know if that's a part of the heart of the problem, is the difference between our world versus their world. And that's the part that needs to be fixed, or is causing concern for Ms. Baker or not. Do we have additional comments?
Sure, if I can just, this is Keith Picker for the record, just respond to that briefly. I agree with that, and that's what I assumed was happening. I'm just pointing out that what I want to avoid is creating a discord within the statutory scheme. That was one of the main reasons that we pushed AB 263 back in 2015, because there were so many. And so I'm just resisting this notion of creating a disparity simply because there is a difference. And I think maybe what we do instead is provide the 4D courts with some guidance on the custodial arrangement. Even though they don't have jurisdiction to make a custody decision, they can certainly look back to the factors, for example, 125C003 sub A or 1A, as guidance for determining where that line is drawn. But what I want to avoid is creating a standard in the guidelines that then contradicts or it could be interpreted to contradict what we've done in the statute.
Okay, thank you, Judge Rob.
It occurs to me too that we are talking about moving the guidepost. The reason, as I understand it, that factor was originally there was back at a time when if you had more than 50% custody, you were the primary physical custodian. That idea has already been subsumed within the Rivero definition of primary physical custody. So we're already looking at a 40% custodial parent still having what would be considered joint physical custody. So they are getting basically the credit for the time that they are doing. Now what we're looking at is giving credit for even fewer hours spent with the child at the kind of at the detriment of the party who is actually the primary physical custodian. I am very resistant to moving that goalpost until we are looking at, is this party spending 25%, for example, time with the child? That is, it's inappropriate to use that as a consideration. I think it's already subsumed within the law that we have. And I don't think it's a good idea to try and resurrect that particular consideration to be used to go beyond that 40%.
Okay, thank you. Additional comments? Ms. Cliff.
Hi, this is Karen Cliff. Clark very rarely used this deviation factor when it was in existence. So this is not something that we are requesting to be added to the NAC, but of course we'll support what the commission decides. But it's not one that we'll use regularly, even if it's added back in. Thanks.
Okay, thank you. Ms. Baker.
My only request would be that we make it very clear in our minutes that time spent is no longer considered an adjustment factor under the NAC, as it is used a lot in my courtroom.
Okay, restate that for me for a second. You're asking that we put it just on the record or that we actually codify something into the NACs regarding that?
No, I don't think we would codify.
Okay.
The
Okay.
adjustment factor does not include time spent, but I do think
Yeah.
that in terms of our meeting minutes, that we're very clear that this was a discussion and that the consensus of the committee is that time spent is no longer an adjustment factor to be considered in calculating a child support obligation.
Okay. That I do believe is starting to shape up in the minutes. I suppose we could make a motion that our minutes state that, but I believe that is wrapping up in the minutes and we have clear intent of this committee at this point. Do we have additional discussion? For the sake of asking, are there any motions or are we moving on to public comment? Okay, we will move on to public comment for discussion item number 13, please.
If you wish to give public comment for item 13, please press star 9 on your phone or press raise hand in your Zoom window. You are unmuted. If you have your hand raised, you may begin.
This is Marshall Willick, and this is not one of the comments from my role as Academy Observer, but from my prior role as the reporter for the 1992 and 1996 versions of this commission. I'll suggest that if you go back and you read the 1992 report, you will find that our discussion of this statutory factor was the reverse of what you're discussing here, not so much a decrease because of increased time spent with the child, but the possibility of an increase in child support where you have a non-custodial parent who spends no time whatsoever with the child because the existing guidelines provided a support amount which already implied a certain minimum level of support of the child while in the non-custodial parent's custody. And where that wasn't even done, where not a single cheeseburger or transportation to a game or anything else was ever purchased for the child, it might be appropriate for a court to actually use this factor as a increase in the child support payable to the custodial parent who has 100% of the out-of-pocket requirements to care for a child.
Okay, additional public comment on agenda item number 13.
If there is anyone wishing to make public comment, please press star 9 now or press raise hand to join the queue in your Zoom window. At this time, Chair, there are no additional hands raised to join the queue for public comment.
Okay, thank you. Committee, we do have an agenda item later at the end regarding discussing future items. So based on any of the public comment on items that I have not did not have remain on the agenda, you can discuss it during that agenda item and let me know whether you would like to keep it on the agenda based on the public comment. We will move on to agenda item number 14, discussion and recommendations on NAC 425.150, subsection D, to determine if public assistance should be defined, and if so, how to define it. We did discuss this last time, and I believe Ms. Cliff was going to work on language for us, and I do believe we have that language.
Yes, this is Karen Cliff. Madam Chair, just for purposes of the agenda, I noticed that we only mentioned NAC 425.150. Both Kathleen and I were tasked with reviewing that, but it also included NAC 425.110. It was both of those sections, and we've provided our revisions to those sections for today's meeting. But since it's not on the agenda, are we able to address 425.110?
Yes, because I believe in terms of defining public assistance, wherever you believe that needs to happen at the moment, it was defined within the subsection included on the agenda, but I believe we're fine to discuss where it needs to be corrected across the board.
Okay. It would be easier just to very quickly discuss NAC 425.110. So that is subsection D.
Would you like me to share it on the screen? Would that be
Yes,
helpful to the
please.
committee? Okay, let me do that. And hopefully I have it right. Do you see 425.110 on the screen? Okay.
Yes, so subsection D was the only section that was revised. Previous language was a broader, just public assistance language. This is very specific to state. It's TANF cash assistance. When Kathleen and I met, the state was online as well. I believe we were all on board with this verbiage. So if the committee could review it.
Okay, for purposes of the record, I'll read it out loud. We're talking about just subsection D, correct? 425.110, which is contain a certification by the obligee that he or she is not currently receiving temporary assistance for needy families / cash assistance and has not applied for temporary assistance for needy families / cash assistance.
The goal was to clarify, sorry, the slash is that, you know, in our world, we're well aware that TANF is cash, but for those that maybe don't understand temporary assistance for needy families, we wanted to identify that it's only the cash assistance we're concerned about, you know, not the Medicaid, the food stamps, and things of that nature.
Okay, I'll make one comment before I solicit other comments. I am not sure, and perhaps Senator Pickard, I don't know if we still have Senator Harris or not, know if LCB is going to have issues with the use of a slash within statutory construction or not. These are the things you get experience with over the years of them knocking things out. But I'll take comments on this now. Senator Pickard.
Thank you, Madam Chair. Keith Pickard for the record. Yeah, we generally try to stay away from slashes because it doesn't usually lead to clarity in terms of interpretation. And so what I would suggest is just reversing the order and say receiving cash assistance such as temporary assistance for needy families. But I also had the question, you know, are we going beyond TANF, or if we would include things like SNAP benefits or other benefits that might be available to families, because ultimately those do add to the economic circumstances of the individuals. If we're not including anything other than TANF, I would just like to get on the record why that is.
Right. So that's where NAC 425, this is Karen Cliff, 150 comes into play, where maybe we just have a generalized public assistance. But in terms of NAC 425.110, it's about providing the authority for parties to stipulate. So the prior language was public assistance. And so what was happening was, let's say a petitioner was receiving food stamps, they were unable to stipulate to a lower child support amount because of the receipt of, let's say, food stamps. That's what we call a non-referable aid code. So the state does not have a position whether the parties stipulate if petitioner is receiving Medicaid or food stamps. The only referable aid code is cash. That's where the state kind of steps in and says, wait a minute, you can't stipulate to a zero order because the petitioner is receiving cash. But with all other benefits, we do not have a position as Clark County, and the state is on board as well, but I'll let them confirm that. So it would just be the TANF that we're addressing in NAC 425.110.
Additional comments? Ms. Chappell?
Margot Chappell for the record. Yes, we're in concurrence with Clark County. Thank you.
Thank you. Additional comments? I think maybe we deal with this. Oh, no, I don't know if we should take public comment between each one. Let's go ahead and move on to 425.150 edits, Ms. Cliff.
Okay, 425.150 edit, that would be subsection D. So for consistency, we removed the public assistance, added the temporary assistance for needy families. But there was a comment when Kathleen and I met from the state about maybe just leaving the public assistance language alone, just leave that section as it stands. And I like that suggestion because there may be instances that, let's say the respondent is receiving food stamps or medical, perhaps the court may want to use that as an adjustment factor downwards. So if we leave it, if we are very specific that it's only TANF, then we run into the situation where, let's say the respondent is receiving food stamps and medical and a lot of other sort of benefits from the state. Would the court like to consider those as adjustment factors downwards? So I'm amenable to leaving NAC 425.150 alone. But again, any feedback from the committee would be wonderful.
Okay, additional comments? None? Leave Ms. Cliff hanging. My personal perspective as a private attorney is this affects me so little that I just want to do whatever works for the DAs to make it work well for DWSS. It's really, truly not going to be applicable to the cases I see, but.
So this is Karen Cliff again. So in terms of NAC 425.110, the ability for parties to stipulate, for Clark along with the state and Kathleen, I believe for Washoe, it would be helpful to specify its TANF so we don't have those rejected stipulations. For 425.150, despite the fact that Kathleen and I made that change, I do like the commentary from our session to just leave this section alone. So no change, but Kathleen, I'll defer to you on this one as well.
All right, Ms. Chappell, I see your hand raised too, or Ms. Baker, either one.
Kathleen Baker for the record. Ms. Cliff and I did discuss the possibility of leaving 150 just as public assistance. And I think that would be helpful. I think the confusion for some people comes in is they don't understand about the definition of public assistance in 422A.065. And I don't know if we have any appetite for referencing that statute so that there is clarity for what that would contain or not.
I like that, Kathleen. This is Karen Cliff. I like the idea of referencing 422A.065.
Chair Surratt, this is Margot Chappell, and the state is in agreement with that suggestion. Thank you.
Okay, thank you. Okay, any further discussion from the committee? Okay, instead of making a motion right now, I think we need to put the proper exact language in front of the committee to make that vote. And then I can incorporate it into the master document. So I am going to leave it on the agenda for right now for that purpose so that we can make those modifications.
Karen Cliff on behalf of Clark. We will make the changes as directed in this session, NAC 425.110 to remove the /, and with NAC 425.150, we will revert the language in subsection D back to the original language, but also with a reference directing everyone to look at NRS 422A.065.
Okay,
and I'll have copies of that for the next meeting.
Okay, perfect. Thank you. Any additional comments before I move on to public comment? Yes, Assemblywoman Cohen.
Thank you, Chair. So I'm looking through 422A.065, and it's not a statute that I usually look at. So if I could just get some information. So if there's housing assistance, is that encompassed in that? I see, I mean, there's reference to benefits provided pursuant to any other public welfare program administered by the division pursuant to additional federal legislation. Yeah, if one of you who happens to know this statute well could just let me know.
I'm sorry, I guess I don't understand the question.
Are housing benefits included in NRS 422A.065? Is it part of the definition of public assistance?
Housing assistance. Let's see, I'm looking at the definition right now. It should be subsection G, which is more of the sort of general benefits provided pursuant to any other public welfare program.
Okay.
But we'll just be referencing 422A.065 in 150. I imagine something along the lines of going back to the definition we previously had and just stating as referenced in NRS 422 or as defined in NRS 422A.065.
Okay, thank you. Like I said, it just isn't one of the statutes that I'm very familiar with, so I wanted to make sure that was included. Thank you.
Judge Hoskin.
Yeah, my only hesitation is I thought we were trying really hard not to reference other statutes that could potentially change as part of what we're doing. I don't have a problem if it's clear that way. I just recall that was part of our discussion in the initial committee. So I just wanted to raise that in case anybody wanted to comment.
Any additional comments?
This is Karen Cliff. I agree with Judge Hoskin's sentiments. The good news is this statute has not changed since I've been here. It looks like the last revision may have been in 2013. So we might be safe if we want to make this one exception, but I will defer.
All right. Additional comments? All right. I think we're safest to reserve the motion until the next meeting, just when we have it exactly as needed in front of us. And we'll be able to hear the public comment before a final decision is made on this. So if we could now move to public comment on agenda item number 14, please.
To offer public comment on agenda item 14 of today's meeting, please press *9 now to take your place in the queue, or raise your hand using the option in the right-hand menu of the Zoom window. Once more, to take your place in the queue to offer public comment, please press *9 now or raise your hand using the option in the Zoom window. Thank you, Chair. It appears there are no attendees wishing to offer public comment at this time.
Okay, thank you. I just noticed in our attendee list, I see Judge Shirley. And I just attempted to move you to panelist, sir. And you are just by phone. But to be clear, to do what the Attorney General's office would like us to do, we need you by video, so I can't count you as officially present, but I do note that you are here and you are part of our committee. All right, we're going to move on to agenda item number 15, which is discussion and recommendation on NAC 425.150 subsection 1E, and whether it should be expanded to cover the cost of a parent to travel for visitation. Again, this is an item we did discuss at the last meeting, and Ms. Baker, we kept it on the agenda to have further comment from you.
Kathleen Baker for the record. This came up because oftentimes with small children, they are not necessarily able to go and visit a parent who lives, for instance, in another state. And if the idea is to support contact between the children and the parents, that we might want to be clear that it is the cost of transportation to facilitate contact between the children and the parent, which would include the parent coming to see the child as well.
Okay, additional committee comments? All right, Ms. Chappell?
Margot Chappell, for the record, I would just state, and this is an opinion as a committee member, that it might not seem fair if the budget of the custodial parent is limited to make the cost of transportation applicable to what they receive. So as long as we're not talking about that, I would think, as long as it's not going to cause a hardship to the child and the family, I would think that it could be allowable, but it might be a case-by-case basis.
Judge Hoskin?
And I think that goes into the comment that I had. We have the ability as judicial officers to consider the cost of transportation in the totality of what we're doing for adjustments. And I think if we get too specific on those issues, then we're going to lose the ability to have the discretion. So I would prefer not to make a change to it because I have an ability to make a case-by-case determination with the language the way that it is now. And I think if we add the additional proposed language, I may not have that ability.
Thank you, Ms. Baker.
So right now, the adjustment factor is the cost of transportation of the child to and from visitation. I'm wondering if because that sounds like it limits it to that cost, whether or not we want to say the cost of transportation to facilitate visitation. Just a thought.
Judge Hoskin?
Yeah, and what I'm looking to the catch-all in 1G, which is where I would put the transportation for the parent in those cases where I think it's appropriate. But I don't know, in all cases, it's not appropriate. I can think of examples on both sides of it, but if we're limiting and either requiring it or completely eliminating it, then I don't have the discretion in those individual cases.
Assemblywoman Cohen?
Thank you. For the record, Leslie Cohen. Why couldn't it actually be just changed to the cost of transportation to and from visitation and take out of the child? And that way there's more flexibility. No one would improperly presume that we specifically only meant child, even though there is that catch-all. I get that, Your Honor, but we also know sometimes people will think if something isn't specifically stated, it's not an option. And that way it leaves transportation very flexible for those cases where the court has the discretion to determine if there should be costs to, for instance, the parent who's helping with transportation.
But I have that discretion now. And if we eliminate it, and I get the point that you're getting to, but I have also those cases where people are coming in and saying, no, this is clearly, it means that parent gets it, because it doesn't say parent, so clearly parent gets to transport, and parent's new spouse gets to transport because that's cost of going on the visitation. I think that when we originally put this together, the cost of the child was considered by the committee as necessary to consider. But the other costs were going to be left discretionary. And I'll apply whatever law we end up doing. I'm just saying that if the intent is to limit the court's case-by-case determination, then more specificity will accomplish that.
Ms. Baker?
Kathleen Baker, for the record. It seems to me that all of the adjustment factors are discretionary because it says may be adjusted. So I think that even if we were to make any changes, and I'm not saying we have to, but even if we were to make changes to the cost of transportation, 1D or 1E, it would still be discretionary for the court to determine what that should be.
Additional comments? Hearing none, do we have any proposed motions on this item? Okay, hearing none. again, this will be another item that, dependent on public comment, I'll make an additional decision whether or not to keep this on the agenda. And when we do future agenda items at the end, we can clarify exactly what we're going to keep on the agenda. But can we please take public comment on agenda item number 15, please?
If you wish to make public comment on agenda item 15, please press star 9 on your phone or the raise hand button in the Zoom window. Once again, if you wish to make public comment on agenda item 15, please press raise hand in the Zoom window or press star 9 on your phone. Chair, at this time, everything is working, but there is no one to give public comment.
Okay, thank you very much. We will move on to agenda item number 16, discussion and recommendations on NAC 425.150, subsection 1G, to determine if the other necessary expenses should be further defined, to discuss what is not intended to be covered, i.e. tuition, extracurricular activities, life insurance, etc. We did have discussion on this during the last meeting, and in deference to the members that were not present, we kept it on the agenda. Do we have any further discussion on item number 16? Hearing none, then we will go on to public comment, and I will consider this agenda item done unless I hear something in public comment that causes us to keep this on the agenda. Can we please take public comment on agenda item number 16?
To offer public comment on agenda item 16 of today's meeting, please press star 9 now to take your place in the queue or use the raise hand function in the Zoom window. Once more, to take your place in the queue, please press star 9 now or use the raise hand function in the Zoom window. Thank you, Chair. It appears there are no callers wishing to offer public comment on this agenda item at this time.
Okay, thank you very much. We will move on to agenda item number 17, discussion and recommendations on NAC 425.155 to include discussion of individuals incarcerated for the months pending resolution of charges, and if the court should set an amount to be paid upon release at the current low income schedule amount. Again, we discussed this a little bit last time, but Ms. Baker, we really needed your input on this, and quite honestly suggested language on this so that we know what to do with it and where to go with it. So if you don't mind cueing us in.
Thank you, Kathleen Baker, for the record. So when we look at NAC 425.155, it talks about the obligor being incarcerated for a period of 180 consecutive days or more to be able to trigger this particular provision. What we have found is that we have a number of parties who have been arrested. They are incarcerated. They are pending arraignment or their trial or sentencing, and they are often there for a significant period of time. I did notice in the minutes that Ms. Cliff had talked about not really using 425.155, but looking the ability to pay for those particular individuals. I certainly think that is an option, but we are clearly in court because the individual is in custody. And I apologize, Madam Chair, but I don't have my language. I think I sent you some language and I don't have it in front of me. So the question is, if we don't know that they're going to be there for 180 days, and they could actually be there for a year or longer, there are people who are pending trial who've been in custody for a significant period of time. Do we need to have the finding that they must be incarcerated for at least 180 days before we can use this provision of the NAC? And I would point out that at least in terms of policy for DWSS, it really talks about a change in circumstances when they will be incarcerated, which sounds like that's a starting point before we move forward on a modification based on incarceration. Feedback would be appreciated.
So I have a question for you, because the language that's in 0.155 is that if the obligor is incarcerated or involuntarily institutionalized. Now, of course, that was consideration towards like mental health, right? Institutionalization, I'm assuming. But are you suggesting that that language isn't broad enough to capture people that are just being held before there's an actual conviction? Or is the 180 days causing problems? Is it too long? Or I'm trying to get to the heart of which part's the problem.
I think that the 180 day, we got that from California. I think we looked at the California statutes and came up with a minimum amount for us to modify. If someone's going to be incarcerated for less than 180 days, then we don't necessarily want to change their child support obligation because it's a temporary situation. If they're going to be incarcerated longer than that, it is not so temporary, and we should probably look at modification. But I think this is narrow in that it doesn't look at those parties, and it means taking a look at, what have they been arrested for? What are the charges they're facing? How long does it look like they're going to be in custody? If they're facing murder 1 charges, chances are they're going to be there for a while, and we should probably bring it before the court. This statute doesn't really address that. And as I indicated, perhaps Ms. Cliff's approach of just looking at their incarcerated, finding out whether they have any source of income and ability to pay may be the answer to it, and looking at the minutes from the last meeting.
Okay, Ms. Chappell?
Margot Chappell, for the record, yes, this program's opinion that setting a minimum, which includes $0 in the income range, should resolve this issue. Thank you.
Okay. Meaning, based on the other changes we have within the agenda, you would not need additional changes to this section. Is that what I'm hearing? Okay.
Correct. Thank you.
Okay, thank you. And Ms. Baker, is that consistent with what you're thinking?
Kathleen Baker, for the record, and it is.
Okay, great. So we won't need a motion on this or change to section 425.155 based on other changes we're making within our agenda. Do we have any additional comments from the committee? Okay, hearing none, unless there's an appetite or a need for a motion, which I'm not hearing, I will move on to public comment. If we could please take public comment on agenda item number 17, please.
If you wish to make public comment on agenda item 17, please press star 9 on your phone or the raise hand button in Zoom to join the queue. Once again, press star 9 on your phone or the raise hand button in the Zoom window in order to make public comment on agenda item 17. Chair, at this time, there is no one wishing to make public comment and there's no one in the queue.
Okay, thank you very much. We will move on to agenda item number 18, which is discuss and approve items for future agenda items. Anything from the committee that you want included or changed or brought back into the agenda at this time? Ms. Chappell?
Chair Margot Chappell, for the record, could you please, I know you've been taking notes about things that are going to be on the next agenda. It might be helpful to review those items so we can identify anything else to add. Thank you.
I absolutely can do that if I can get to the right page. So our first item, I think we are, so I'm going to go through the agenda items and just tell you if I feel like they're done and they're not coming back, or if they are coming back. Agenda item number 4 is done. We will not keep it. Number 5, we are going to keep on the agenda. 6, keep. 7, keep. 8, keep. 9, keep. 10 is technically a keep, but it's really within other items now because of the reorganization. I'm sorry, I need to make a better note for myself. So it's not a separate item, but it fits within a different agenda item. Number 11, we will keep. 12, we are done and will not return. 13, we are done and will not return. 14, we are keeping mainly just to get the final language in front of us for a vote. 15 is done, 16 is done, and 17 is done. And when I say done, I mean it's not returning on the agenda. Is everybody on board with me? Did I get it right? Okay. Any additional new items? Okay, and for those of you that are listening within the public, we're going to go to public comment, but please note that this committee is all ears for potential items to place on the agenda and discuss. If they are items that this committee has thoroughly vetted already, there is a likelihood I won't put it on the agenda, but I will reference you to the prior meeting minutes and videos, which thankfully we will have up on the internet here soon to make that easier to accomplish. With that, do we have any other items anybody wants to add to the agenda before I move on to the next item? Okay.
Do it.
Do it. Agenda item number 19 is public comment. At this point, this is our general public comment. We are not relegated to specific agenda items. For this part of it, you will be timed at 2 minutes per public comment. And can we please take public comment now?
If you would like to offer public comment on today's meeting, please press *9 now if you are on the phone, or use the raise hand function in Zoom if you are using a client. Once more, that's *9 now or using the raise hand function to take your place in the queue to offer public comment on today's meeting. If your hand is raised, you are unmuted and you may begin.
All right, sir, please state your full name before your public comment.
Store. And my public comment has to do with NAC 150.
Sir, it's really hard to hear you. If you could, I don't know if you're on a speakerphone or a long ways from your phone. We'd love to be able to hear you.
Okay, I'll speak up. My name is Andrew Pastor, and I'm talking about NAC 425, subsection 1F. I know that this was discussed previously on the September 17th meeting, but I believe that the portion that I would like to discuss was not addressed. The last portion of that, last phrase of that subsection has to do with the phrase is so long as the adjustment does not exceed the total obligation of the other party. I'd like to point out that the term other party is defined in NAC 425-115. In subsection 2 of that, it defines the other party to be the obligor if one party has primary physical custody. So in that section, the other party is the party paying the obligee. However, in subsection 3 of 425-115, the other party is defined as the person receiving the money. And so there seems to be some disconnect between 425-115 and 425-150 with regard to how the other party is defined. Furthermore, in the case of a high income earner where one party has a much higher income than the other, it doesn't really make any sense to limit the adjustment that could be made to a high income earner's obligation if the other party is the party receiving the money. So just by way of example, if somebody has an say a monthly obligation of say $10,000 according to their income under 425-140, and the party receiving the money would have either no obligation if they're the primary caregiver, or a much smaller obligation if it's joint custody. It certainly doesn't make any sense to limit the adjustment that can be made based on a person, the other party's income, if that other party means the party receiving the money. So I'd just like to point that out. And it seems to me, at least, that the term other party needs to be revised.
Okay, thank you, sir. Do we have any additional public comment?
There are any other, excuse me, I'm sorry.
No,
If there are
I'm sorry.
any other callers wishing to offer public comment on today's meeting, please press *9 now or raise your hand to take your place in the queue. Thank you, Chair. It appears there are no other callers wishing to offer public comment at this time.
Okay, thank you. Thank you for your public comment, Mr. Pastor. That's extremely helpful for this committee, and I do believe it fell within one of our agenda items, and we will be able to address it on the next agenda within the reorganization and the definitions and the clarifying language, defining language consistently. But we appreciate your time, and those of you that are also listening today but did not participate, please know that we welcome your comments. We welcome you to do public comment and give us suggestions and ideas. And especially when those ideas come with specific language changes for us, it is extremely helpful. We are deep into these child support statutes at this point, and we are blind to some of the inconsistencies because we've seen the language 500 times over, rewritten it in front of us, and it gets hard to see it. But I will, at this point, move us on to the last agenda item, which is a adjournment. If I have anybody willing to make a motion to adjourn.
So moved.
I have no, Judge Hoskin was the loudest, I think, because he has the deepest voice. So I don't know who else, but who's seconds?
Oh, second.
Judge Rob. All right, any further discussion? Oh, yes.
Chair Surratt, this is Margot Chappell. For the record, I just wanted to state that we'll have Joy send out an announcement when all of the meeting minutes have been posted. And I put the link to that website in the chat. Thank you.
Okay, thank you. Mr. Fleeman?
Yeah, just for the record, I'm not sure that it matters, but at the beginning, we took the agenda item of the minutes and adopting them. I didn't vote during that. There was no offer of abstention. I would have abstained. I wasn't here at the last meeting, so I just
will
want to
record your abstention, yes.
All right, thank you.
Thank you. All right. All in favor to adjourn?
Aye.
Aye.
Anybody opposed? Any abstentions? All right, thank you, everyone. As soon as we figure out the next date for the next meeting, we will get notice out to everybody.
Thanks, Chair.
Thank you.
Thank you, everyone.
Thank you, everyone. Thanks, Chair. Nice, good meeting.
Thank you.
Bye, everyone.
Bye-bye.